Yes. Let's start.
Yes.
Hon'ble Mr. Justice C.S. Dias, Judge, High Court of Kerala, our esteemed guest, Professor Dr. Skelton, Mr. Kiran Mohandas, my co-directors, learned participants. Good evening to you all. It's my honor and privilege to welcome you all to today's special dialogue session on child rights, national and international perspectives. This is a subject of immense significance and one that not only addresses the legal and social protection of children, but also lays the foundation for the future of our societies. Obviously, this is the third episode of Kerala Global Justice Dialogues, hosted by the Kerala Judicial Academy in collaboration with Nuremberg Principals Academy. And the topic was selected considering its huge importance on today's world scenario. As far as Kerala Judicial Academy is concerned, it's noteworthy that over 50% of our judicial officers of the state are women. We are also proud to have strong female representation within our academy, notably through our Assistant Director, Dr. Anthony Alex. Her name might spark a bit curiosity for our esteemed guest today, given the coincidental similarity in their first names. That said, we are deeply honored to be joined today by Professor Dr. Skelton, one of the world's foremost voices in the field of child rights. Professor Skelton is a globally respected authority in child law and human rights. Her tireless advocacy and extensive scholarship have left a transformative impact both nationally and internationally. She holds the UNESCO Chair in Education Law in Africa and serves as Professor of Law at the University of Pretoria, Leiden University in the Netherlands. Her remarkable contributions span across child protection systems, legal reform, and international policy development. Notably, Professor Skelton is a member of the United Nations Committee on the Rights of Child, where she continues to influence the guide and global discourse on child rights. Her work has earned her numerous accolades, including recognition as one of the South Africa's leading human rights lawyers. She continues to inspire practitioners, academics, and students across the globe. We are truly privileged to have her with us today and share her insight to the national and international dimension of child rights, an issue that is more pressing and relevant than ever in today's complex and challenging world. On behalf of the Kerala Judicial Academy, and also on behalf of all who gathered virtually here, I extend a very warm welcome to you, Professor Skelton. We are truly honored by your presence, and we look forward to learning from your immense experience and wisdom. Equally, we are privileged to have amongst us Honorable Mr. Justice C.S. Dias, Judge, High Court of Kerala, a towering figure in the area of child rights and adoption in this part of the world. With all humility and reverence, I extend a heartfelt welcome to your Lordship to this virtual class. Let us also extend a warm round of applause to welcome Professor Dr. Skelton and Honorable Mr. Justice C.S. Dias. With this, I now have the pleasure of handing over the virtual floor to Mr. Kiran Mohandas Menon, Senior Officer at the International Nuremberg Principals Academy, Nuremberg, for formal introduction of Professor Dr. Skelton. Thank you. Jai Hind.
Thank you very much, and good afternoon to everybody from my side as well. I have the true privilege of introducing Professor Skelton today. You've already mentioned the various academic appointments that she holds. I can perhaps add that she was a member of the United Nations Committee on the Rights of the Child from March 2017 to February 2025, the last 2 years of which she was the chairperson of the committee. This, you may know, is the international body of 18 independent experts that monitors implementation of the Convention on the Rights to the Child, the convention having 196, of which 196 countries are party to, including every member of the United Nations except for the notable exception of the United States of America. In Professor Skelton's home country of South Africa, she has played a leading role in child law reform through her involvement with the committees of the South African Law Reform Commission. When Nelson Mandela became president of South Africa, Professor Skelton was asked to chair the writing of new legislation to protect children in trouble with the law. And she's been involved in the drafting of both South African Child Justice Act and Children's Act, respectively. She has also led influential strategic litigation proceedings in relation to children's rights as legal counsel in several landmark cases. Among her many awards include the Honorary World Children's Prize, presented by the Queen of Sweden in 2012, and the Juvenile Justice Without Borders Award, presented by the International Observatory on Juvenile Justice in 2017. I will stop listing her accomplishments now, or we won't have time for this dialogue. I'll just take a moment also to thank Professor Skelton for joining us today and hand over the floor. Thank you.
Well, greetings, everyone, and thank you very much for all those kind words of introduction. I'm actually speaking to you from South Africa, and I have spent most of my career working on children's rights in South Africa, and in the last decade then moved to the international level. So I am very familiar with the fact that the real work of children's rights protection happens on the ground. As I often like to say, there are no children in the international arena. All children live somewhere in a country. And so what happens on the ground is really very, very important. And that's why the work being done by people working with children and for children, like yourselves, who work in the courts and alongside children in various other capacities, are really such important role players for ensuring and upholding children's rights in the most important way possible. The Convention on the Rights of the Child is a very important instrument because it sets the standard according to which all countries are supposed to align their laws and their policies and their practices and make sure that they budget accordingly to bring all of that in line with the Convention on the Rights of the Child. And so, in a sense, it means we have a global consensus on what we should be doing and where we should be going in terms of child rights protection. And of course, different countries are at different stages of implementation. The Convention has been around since 1989, so it's 35 years old. But various countries ratified it at different stages and are at different levels in terms of their compliance. So how do we know where countries are in terms of their compliance? I'm just going to ask the speaker, Nanda Kumar, to please mute. Thank you. I think what's important is that there has to be some monitoring, right? So that we know where our country's doing what needs to be in, and that's where the Committee on the Rights of the Child comes in. It's an 18-member committee. It sits in Geneva, and its main task is to monitor the compliance of states on the Convention's implementation at the national level. So this involves states sending delegations to Geneva, and usually those delegations are headed up by a minister, perhaps the Minister of Justice or the Minister of Social Welfare, something like that. And then usually people from ministries, all the ministries, so that they can answer questions that the committee will pose. Now, I'm sad to tell you that the last time that India did this was in 2014, 11 years ago. And actually, these reports are supposed to be compiled and sent in every 5 years. There is always a little bit of a backlog, it's true, but it seems that India has missed at least one reporting cycle. That last report that was submitted was the third and fourth periodic reports put together. So they'd already missed one, but at least they then put them together and reported. So it's high time that India should make its next report to the Committee on the Rights of the Child. The idea of this is it's a cycle. So in between the 5-year appearances at the Committee on the Rights of the Child, the state has to act on the concluding observations, which are basically recommendations that are put forward by the committee to the states to say, look, this is where you're coming a little short, you're falling a little short in terms of your children's rights compliance, and these are our recommendations about what you should do. So then in the 5 years after the reporting, the state should be fully engaged with trying to make sure that all of those recommendations are complied with, so that when they come back again, the committee, they can report and say, well, we've managed to do all of these things. So one of the things, by the way, I just looked at the last concluding observations before coming to speak to you today, and I saw that one of the things that was recommended, that there should be ongoing training, including of judicial officers. So here we are. Well done. You're actually complying with one of the recommendations that was put forward by the Committee on the Rights of the Child. But there were many others, pertaining to practices in the courts. For example, the committee wanted to know what measures had been taken to ensure that children's best interests were really at the heart of decisions being made by courts, and to what extent children's voices were being heard, were children being asked to give an opinion in all the decisions that are made about them. So when India next comes to the Committee on the Rights of the Child, then that will be the opportunity to tell the committee what has been done in the interim period on those two issues and many, many other issues. Another important thing, of course, is that there are optional protocols, and I see that India has ratified the optional protocol on sale, sexual exploitation and child pornography of children, and also has reported, done the initial report on that as well. And then when India comes next time, they can combine the two together and just do that as one report. So I do hope those processes are underway, so that the children of India can benefit from the fact that the committee will provide some guidance and advice to the government of India in this regard. There is a third optional protocol to the convention, and that is one on a communications procedure. It's a bit of a strange word, communications procedure. It would probably be easier to understand if it was called a complaints procedure. That's what it is, actually. It's so that if a child, if the child's rights have been violated, after they have attempted to get justice at the national level, and if they have not been successful in that, or if all their efforts are just not going to prove successful, then they can come to the Committee on the Rights of the Child. And then the committee will assess whether or not the child's rights have been violated by the state. And this can be for an individual child, but it can also be for groups of children. Now, this is a fascinating and important mechanism. It was one of my favorite parts of the work of the Committee on the Rights of the Child, because it's quasi-judicial work, which I really enjoy. Because of my background in strategic litigation, this is another kind of PIL, as people in India like to refer to strategic litigation. And it's PIL at the international level. So it's a pity that India hasn't ratified the third optional protocol. But you're not alone. South Africa hasn't ratified it either, which I'm pretty annoyed about. And I keep telling them that it's about time. So please, will you get on to the government of India and tell them it's about time that they ratified this third optional protocol. Not many countries in Asia have done so, but Thailand has. So you shouldn't be left behind. It's important, I think, for this optional protocol to be ratified by states in Asia, so that children in Asia also have this opportunity. It isn't something that is overused, because, again, I would acknowledge that it's important for children to be able to get access to justice at the national level. We don't want children to have to come all the way to the international bodies to get justice. Justice should be available as close to where children are as possible. And I think that in many ways, India does have fantastic access to justice possibilities. Now, the Committee on the Rights of the Child is currently drafting its 27th general comment. General comments are interpretive documents that the committee drafts from time to time. And the current one is on access to justice and remedies. And you know, not all countries in the world have the kind of access to justice that you do in India. The fact that people can, you know, bring petitions in a very simple way, actually. Your standing rules are extremely flexible in India. And I've always been fascinated by the fact that Indian judges can start cases of their own accord, mero motu, a very unusual thing. You probably take it for granted because you're Indian. But everywhere else in the world, it's usually a lot more difficult than that. You can't just, you don't get judges waking up in the morning and deciding to start a PIL in many countries in the world. So in this regard, there is, I know, a lot of activism, judicial activism, and there is a lot of civil society activism, which is very good. One word on that, though, is that it's very important to follow through on this. It's no good getting hundreds of judgments all over the place and then none of them are ever implemented. So those of you who are engaged or interested in PIL, I think that's another frontier. And an interesting idea is, are children really consulted in these kinds of PILs that involve them? Do they even know about the remedies that have been won on their behalf? Are they ever involved in monitoring the outcomes of these cases? So that's also interesting new frontiers. And this new general comment on access to justice is actually a very fine place for the committee to start giving some guidance in that regard. So I do think that these developments at the committee could benefit from having comments and guidance from Indian lawyers and practitioners. The draft general comment is available on the committee's website if you're interested to go and look at that. Unfortunately, one of the big consultation processes is already completed. No doubt some Indian children's rights experts already did make comments on it, but there may be another round of possible consultations, and I think that would be very useful to get feedback from a country that does already have a lot of access to justice. But in this process of developing more guidance on access to justice and effective remedy, it's an interesting question. What is an effective remedy when we're talking about children's rights? I was just reading today in the news that a judge in Australia, Judge Beecroft, has just written a letter to a child who was very unhappy about being forced to have contact with his father. Now, I understand some of you are in family court, so this will be a familiar kind of scenario to you. And this little boy was so upset that he refused to get into the car to be taken to meet with his father, and he refused to get on the airplane to fly elsewhere because he was afraid he wouldn't be able to come home. Well, in the end, the court did insist that he have contact with his father, I'm sure after careful consideration of a lot of factors. But interesting thing was that Judge Beecroft then decided to write a letter to the boy. In addition to the usual judgment that he wrote a letter to him explaining what it was all about. And in this letter, there are many references to sport, because both the judge and the boy liked sport a lot. And so he, really brought himself to this level, to the space where the boy could understand and explain himself. It's not the first time that I've heard of judges doing this, but I must say it is still unfortunately very rare. Let me tell you about a case that we had at the Committee on the Rights of the Child, where we also wrote a letter, and it was an open letter. This was a case brought by 16 children to the Committee on the Rights of the Child, alleging that they were suffering harms as a result of climate change effects. Now, they brought the cases, they brought 5 cases against Argentina, Brazil, France, Germany, and Turkey. Those were the states against which they brought the cases. But they were living in those countries. This was very interesting. Some of them were, but some of them were living in other countries. But they were saying, but nevertheless, we are affected because air pollution doesn't stay within countries' boundaries. It moves across into international boundaries. And so this case was actually very interesting from a point of view of extraterritorial jurisdiction. In other words, could a state be held responsible for harms caused to children in another country, not the country where they are, because of the failure to control carbon emissions in the country where they are, which had then caused air pollution affecting children elsewhere. I won't go into all the technical detail. It's quite a technical decision, but there were many problems with the way that the case was brought. It was highly ambitious, and the children, obviously advised by their lawyers, they did have lawyers, did not attempt to exhaust any domestic remedies. And you'll remember I explained at the beginning that children have to exhaust their domestic remedies, have to try first at the national level before coming to the international level. Well, in this case, the children didn't try at all. They just said, it's not possible for us to get the kind of decision we want at the country level, so we're coming straight to the committee. So unfortunately, the committee had to find that the case was inadmissible. But the committee nevertheless decided to deal with the question of jurisdiction, and to say that the committee said that it would not have found it a bar to jurisdiction that the children were living in different countries from the ones against which they were bringing the claim. And this part of the decision was based on a decision of the Inter-American Court of Human Rights, which had already established extraterritorial jurisdiction. This is a big issue going on in the world at the moment, with both the Inter-American Court and the International Court of Justice having issued recent advisory opinions. But this is actually based on an older advisory opinion that had been requested by Colombia. And anyway, the Committee on the Rights of the Child made a decision that they would accept cases in the future, even if they were from children that were not in the state where the harm was coming. So that's interesting. But nevertheless, we knew that the children would be disappointed that their case was found to be inadmissible, and therefore there was no decision on the merits of the case and no remedy. And so the committee decided to write an open letter to the children, explaining to them why that was the case, and encouraging them, to continue with their work and their important work that they were doing as child rights activists, and telling them as well that they had put this issue so firmly on the agenda of the committee that the committee had decided that its next general comment, that was general comment number 26, now the last one of the committee, would be on children's rights and the environment, with a special focus on climate change. And so that's how the committee came to choose that as the theme for its last general comment. Also a very interesting document for any of you who are interested in the effects of climate change. And there is a connection as well, because children more and more are at the forefront of some of these climate cases that are being brought before the courts. It's fascinating to see all of the developments that are happening around access to justice in that space as well, the climate space. And I think we can expect to see more of this. And why children? I mean, we're all affected by climate change, right? So it could be a case brought by adults, true. But there is evidence, there is scientific evidence that children, especially young children, are particularly affected by certain types of climate effects, like air pollution, so that's general environmental degradation issues. And the Convention on the Rights of the Child actually does mention air pollution in Article 24. So that's also quite interesting. And so therefore, the committee has also found now that children do have a right to a clean, healthy and sustainable environment. And if you look at various articles of the convention, this comes through and is clear. So the convention is starting to be used more and more by national litigators as well in supporting their claims of climate harms. But there is another reason maybe why children are getting so involved. Well, first of all, they are worried about climate change, right? That's something that's really of concern to them. So they have stepped up to the front of the queue. But I think another point is that they often say that they speak for future generations. Now, it's important to distinguish children and future generations are not the same thing. But there is, the fact is that if future generations are people who are not born yet, then tomorrow a baby is born and that baby then becomes part of our generation. So that the nexus between today's generation and future generations is just that, the difference between today and tomorrow, or this minute and next minute. And so in a sense, you could say that children are the closest to the future generations. And very importantly, they will live longer into the future. I actually attended COP when I was the chairperson of the Committee of the Rights of the Child, and I had a conversation there with a 12-year-old, and she said to me, don't be upset by what I'm going to say now, but you're not going to live very long. That's what she said to me. Whereas, as she pointed out, she is going to live long, and so she's very worried about climate change. Quite understandable. So yes, I think there is a real reason why children are stepping up and are expressing themselves so strongly about this. And so we do see children really standing up for their own rights as well. And in India, you have seen this in other contexts too, where children have been protesting and fighting for their rights in relation to citizenship, for example. So we're in an era where children are understanding that they are rights holders. That's the Convention on the Rights of the Child speaking to them, and them speaking, using that voice that it gives them. And so I think it's very important to recognize that the world is adjusting and must adjust to the fact that children aren't just beneficiaries of our kindness. They are actually human beings who have human rights, just like us adults, right? So they don't necessarily have all the same rights, of course. They, for example, can't vote, although that space is changing too, because quite a few countries are now starting to give children the vote, particularly in municipal elections. And so I think we can also see that children are exerting their opinions, they are expressing their views. Sometimes they get into trouble for this, and then it will be the job of lawyers and judges to make sure that their rights are upheld if they are in trouble. I think that's most of what I wanted to say to you. Perhaps just to flag as well, I also noticed that that India has not ratified the Hague Convention on international child abduction. And that is a bit of a concern because many children are crossing borders and it becomes very difficult to sort out those issues at the national level. I'm going to pause there and hand back to the organizers, but I especially have not used every moment that was allocated to me because I'd like to leave some time for questions and answers as well.
Thank you, Professor Skelton. That amazing speech. And we are just entering into our next session. I welcome Hon'ble Mr. Justice C.S. Dias to present the Indian perspective and also on the basis of reflections from his experience from the bench. His Lordship, please.
Yes. Dear Professor Dr. Anne Skelton, my esteemed sister and brother judges, directors of the Kerala Judicial Academy, Mr. Kiran Menon, dear judicial officers, distinguished guests, and all my dear friends, very good evening to all of you. At the outset, I extend my sincere gratitude to Dr. Anne for an enlightening and insightful lecture on the global perspective of child rights. Your lecture has broadened our vision on the subject and reminded us that child rights are not merely a legal issue, but also a moral imperative. My director, Mr. Sujit, in his infinite optimism, believes that I can perform a miracle by speaking on the Indian judicial perspective on this intricate subject of child rights in India in a concise discourse of about 15 minutes. I shall make an earnest attempt to navigate the periphery of the subject within the allotted time. A child shows a man as morning shows the day, said renowned poet John Milton. What poetry and what truth. This simple yet profound statement captures the essence of childhood as the formative reflection of life yet to unfold. It is Milton's words that Justice P.N. Bhagavati commented with landmark judgment in Lakshmikant Pandey versus Union of India, a decision that laid down the normative and procedural guidelines for intercountry adoptions, and that was first of a kind in the country wherein the Supreme Court exercised its parents patria jurisdiction for laying down guidelines when the Parliament had failed to formulate any guidelines or any statutory law in this regard. The inherent worth of childhood, its fragility, the potential and the promise, has consistently guided our legal system to safeguard children from harm, exploitation, and neglect. The child is the seed of the future. Protect the seed and you protect the forest. Ours is a nation of unparalleled diversity. We have 29 states, 8 union territories, 22 official languages, nearly 2,000 dialects, and citizens practicing every other religion the world has seen. According to the 2011 census, India has about 472 million children under the age of 18, which represents 18% of the world's child population. This is a source of immense pride and an enormous responsibility for our country. In the 75 years of independent India, we have seen notable strides in recognizing and safeguarding the rights of the children. Our legal framework is pluralistic, an intricate and tapestry woven of statutory, customary, and personal laws. While the family remains the primary custodian of the child, the state is obligated to intervene when the child's best interests are jeopardized. Our interpret family laws and the fragmented legal provisions often impede and the decisive actions. The disparity in childhood experience is one of the most significant challenges that we have faced. You may see at the very same traffic signal a child in a luxurious limousine and another child hawking goods to sustain his family. This inequality is perhaps our greatest challenge. The concept of children as right holders is relatively recent development. Historically, children were viewed as miniature adults. It was in 1840, as Dr. Anne may say, that France took the first step to implement special protection for children. The devastation of the World War I compelled the international community to acknowledge the acute vulnerability of children. In 1924, the International Save the Children Union adopted the Declaration of Rights of Children, which was later endorsed by the Geneva Declaration and adopted by the League of Nations, which went on to become the United Nations. This historic instrument was the first to affirm rights specific to children and to declare corresponding obligations of adults. The atrocities of the World War II again exposed the fragility of children in time of conflict, which catalyzed the establishment of the UNICEF, were tasked with the duty to elevate the plight of millions of displaced and destitute children. In 1959, the United Nations General Assembly adopted the Declaration of Rights of Child, though it did not command universal ratification. India's pre-independence legislative efforts, such as the Apprenticeship Act of 1850 and the Reformative Schools Act of 1897, were the modest beginnings which aimed at the recognition of special needs of children in conflict with the law. Different states came up with different statutes and legislations to meet the special needs of children. Our framers of the Constitution were not oblivious to guaranteeing fundamental rights to children. Article 15 of the state is obliged to make special provisions for children for their well-being and development of the country. By the 86th Amendment to the Constitution, Article 21A was incorporated, mandating that the state to provide free and compulsory education to all children between the age of 6 and 14. Similarly, Article 24 prohibits children below the age of 14 from being employed in any factory or any hazardous employment. Article 39 prohibits child labor, 39(1)(f) stipulates the children are given opportunities to develop healthily and be protected from exploitation. Article 45 mandates the children below 6 years are given early childhood care and education. Article 51A obligates the parents and the guardians to provide education to the child. Some of the vital pre-constitutional amendments which are saved by the adaptation of laws which are still in force are the Indian Majority Act, the Guardian and Wards Act, the Child Marriage Restraint Act, Children Pledging Labour Act, and as per the constitutional directive, the Parliament and state legislatures adopted and enacted various laws, including the Young Personnel Harmful Publication Act, the Medical Termination of Pregnancy Act, the Family Courts Act, the Commission for Protection of Children's Act, the Juvenile Justice Care and Protection of Children's Act, the Preconception and Prenatal Diagnostic Techniques Act, the Prohibition of Child Marriage Act, the Right of Children to Free Education and Compulsory Education Act. And then we had the revolutionary Protection of Children from Sexual Offence Act, which we call POCSO Act, enacted in 2012. After the gruesome Nirbhaya incident, which we are all aware of, in 2012 in Delhi, we have witnessed the penal code also being amended and the offences being incorporated against women and children being incorporated. Our laws, regardless of their noble intentions, remain ineffective unless they are interpreted and enforced. The Indian judiciary has played a transformative role, not merely interpreting statutes, but also actively shaping jurisprudence to uphold the fundamental statutory and human rights of children. Through judicial interventions, the courts have played a very significant role in protecting the fundamental statutory and human rights of children, ensuring that they are shielded from exploitation, abuse, trafficking, and their best interest is protected. The proactive role of the courts forms the bedrock of our nation's commitment to its youngest citizens. You may all have heard that the fundamental criteria for a court in deciding a child rights matter is to secure the child's paramount welfare and best interest. What are these terms, welfare and best interest? You will not find the terms defined in any of the earlier legislations. The terms were interpreted and determined by the Supreme Court and the High Courts from time to time, depending on the facts and circumstances of each case. The legislators, in their wisdom, have not defined these terms because they felt it is to be left flexible and there cannot be any hard and fast rule to term what is best interest and paramount welfare. The Supreme Court, in one of the foremost judgments, named Rosie Jacob versus Jacob A. Chalmarakel, has defined what is best interest and paramount welfare. In fact, that judgment still rules the roost, and all the courts continue to follow the said judgment. Then we have another revolutionary judgment that came in 2019, named Peri Kransagra versus Smriti Kransagra. The Supreme Court emphasized that welfare of the minor child must always take precedence over statutory provisions of custody as delineated by any personal law. In Gaurav Nagpal and Sumit Nagpal, Supreme Court said children are not mere cattle or toys for their parents to control. The fundamental principle that courts have ensured that child's best interest and paramount welfare is secured. Passing an order may seem simple, but it's most complex job. There's an onerous responsibility bestowed on courts. Determining best interest is not a mathematical exercise. You cannot leave it to AI or ChatGPT to resolve, but it's an art of judicial empathy, discretion, and precision. The best interest and paramount welfare of a child seen in the limousine may not be the same as that one who's walking products on the road. This is where law and justice play a very important role. I always say judges are akin to pediatricians in child rights matters. I say it because judges decide paramount welfare based on the circumstances, like pediatricians treat based on symptoms, because child can't speak and you have no time to waste. In child rights matters, judges should act swiftly and sensitively and ensure the child's welfare is secured. It's challenging to balance the child rights with the rival claims of the parents or guardians in such matters. Perhaps recognizing this difficulty, the Parliament felt it was time what is best interest to be inserted by way of Section 2(9) in the Juvenile Justice Care and Protection of Children Act, wherein for the first time in the country, the Parliament has actually defined what is best interest and what is the definitions of principles of best interest have been defined in Section 3(4) of the Act. The Act also defines various other terms that are required in child rights matters. So when in doubt, you as a judge can always fall upon the Juvenile Justice Act and draw an analogy from the principles of law laid down in the legislation. I said it is an onerous responsibility to decide a welfare and best interest of the child because we as judges are not sure that the child or the parties are speaking the whole truth. The child, for his protection, may take sides with either of the parties, despite that not being in his best interest. And we as judges may not have the time to study the child and its surroundings before passing an order. That is why in our legal framework, in a child rights matter, there's always an order and not a judgment. And the matter does not attain finality until the child attains majority. The orders can be varied and modified depending on the circumstances. In fact, in one of the most revolutionary decisions of the recent times, the High Court of Kerala, while dealing with a custody matter named X versus Y, directed that in child rights matters, an independent lawyer be appointed to ascertain the views of the child and to speak to the child and speak for the child to the court at the state's expense, so that the courts would find it very easy to find out what the child's real intention is, and he be along with the child as his guardian till the child attains majority. On the basis of the said directives, the Legal Service Authority, which is under the Legal Service Authority Act, has formulated a scheme named Child Legal Assistance Program, which we colloquially say as CLAP, or fondly say as CLAP, where panel lawyers are appointed by the courts for a child to help the court adjudicate on his rights and what is the decision that he is to take, that too at the expense of the state. We have panel lawyers, they were all recruited in all the courts across the state who are there along with the child, and the courts, when in doubt, will appoint a child when the court feels that the child's rights have to be expressed to the court. And it's very important to learn whether it's the child's actual sayings or whether it's the parents who are behind him to give his opinion. This was one of the most significant and steps that were taken in the recent times in the best interest of the child. We have also seen the Supreme Court step in numerous child rights matters were involved. Some of the celebrated judgments are Sila Barsi versus Union of India, where the Supreme Court took up the cause of illegally detained child and said they require environmentally child-friendly treatment and a distinct system of being detained in prisons. We've also seen MC Mehta versus State of Tamil Nadu, where the Supreme Court banned child labor in Asaras Industries. And Lakshmikant Pandey, as I already spoke at the beginning, wherein elaborate guidelines were laid by the Supreme Court to see that children are taken abroad only after following the stipulations laid down by the Supreme Court. Then we see Gaurav Jain versus Union of India, where children of ladies who are in the flesh trade were said to having a right of dignity, care, and protection. And Vineet versus Union of India dealt with sexual exploitation of children and highlighted the deplorable conditions faced by poverty-stricken children. Court should always bear in mind that child is under a legal disability. Therefore, it's a principal duty of the courts to secure their best interest. In the earliest of times, powers were conferred on the courts. The powers were conferred on the crown, as which was exercised, which we normally say parents' patria jurisdiction. This power that was transferred to the courts, and the courts exercise the power when we do not have a legal framework or a statutory provision to help a child in need of care and protection. With a large number of Indian diaspora outside, one of the most pressing issues which our courts have faced in the recent times is the cross-border child abduction cases. In such battles, the law may favor one side, but the child's interest may be secured in the hands of the opposite party. And it is here the principle of committee of courts, which emphasizes mutual respect between courts of different jurisdictions, was upheld as a guiding doctrine in such matters. In fact, the Supreme Court has stepped in Yashoda Sahu versus State of Rajasthan and gone on to accept the doctrine of committee of courts and most intimate conduct. And Supreme Court emphasized that even if the child's rights are being compromised, the parent who's denied custody should be given visitation and contact rights. This is one revolutionary step. These are all the sides of one story, but the rights on paper are not enough. In an era of rapid technology change, urban migration, and economic volatility, children face new vulnerabilities, sometimes as victims and sometimes as offenders. We must therefore nurture not only the laws, but also the social ethos that values and safeguards the childhood. By the time the case reaches the court, the wound is often deep. The law can heal, but it cannot undo the injury. The child is not merely a citizen of tomorrow. They are the living heartbeat of today. Our collective duty is to ensure that each child's path is one of safety, dignity, and boundless opportunity, and they may truly fulfill the promise which they entered into the world. So the time is ripe to have a very robust society that caters to the welfare and best interests of the child. Advancing child rights require a range of actions beyond just creating laws. It is our collective duty as a society to ensure that every child is allowed to develop to its full potential. They are not merely the future, but they are the present. We must ensure that their journey is one of safety, dignity, and opportunity, and they truly become the blessing to the world that they are destined for. Thank you, Jane.
Thank you, Ms. Lordship, for presenting your insight, and especially on with the word judicial empathy, which cannot be substituted by artificial intelligence in child right matters. So now the floor is open for discussion. We have received certain questions, and I request Mr. Kiran Mohandas Menon to moderate this questionnaire session and start the question which is forwarded to you from our side.
Thank you very much. I also just want to emphasize, please use the raised hand function or the chat if you have any additional questions. But Professor Skelton, I'd start by asking you if you could reflect a little bit on the international discourse of standards when it comes to gender-based violence against adolescent children, and if there are any judicial innovations or legal frameworks that you think are worth India adopting or taking inspiration from.
Yes, well, actually, interestingly enough, the committee doesn't always use the terminology gender-based violence, because of the fact that children experience violence in so many different forms that actually are not related to their gender. So that it's often just related to their status as children and the fact that they are dependent on adults and that they are exposed to violence. But of course, in some instances, there definitely is a clear pattern of gender-based violence as well. And this one sees amongst adolescent children, especially girls, but also sometimes amongst the LGBTI community, which might also be gender-based violence. So I would say that in that context, the committee, when faced with that kind of complaint, will make very specific recommendations. And I think this always requires working with communities as well, because it's to do with a change of mindset. The idea that obviously gender-based violence is brought about through misconceptions, misogyny, and other types of patriarchal views that leads to that situation. But above and beyond that, there is a broader concern of just violence against children. And that is the idea that because they're children, they can somehow be hit when no one else can be harmed or hit. And so in a way, we've still got a long journey ahead of us to persuade people, parents, teachers, people caring for children, that it's not okay to hit children. It's not okay to hit adults. So it's also not okay to hit children, and that there are other ways of managing children's behavior. So I see it as part of a bigger conversation, but all of it requires a mindset change that, yes, is still far from being achieved.
Thank you. Are there any other questions from the audience, or should I proceed with more questions from the chat? I see from the Kerala Judicial Academy. Thank you.
Leave it to the participants. If anyone is interested, they can raise their hands and ask the question directly to our speakers.
Somebody has asked Parvati from here.
Yes, Parvati, please.
Yes, good evening. My question is for Professor Anne Skelton. Would you have any recommendations on the immediate steps that India can take in order to better implement the evolving capacities of the child, particularly in the context of adolescents who are almost, reaching the reaching majority, the adult marker, the marker of adulthood?
Yes, well, I think the concept of evolving capacity is a very crucial aspect of understanding children's rights, because obviously childhood goes all the way from 0 up to 18. So that's a huge variation. And in fact, it is the most rapid period of development that human being goes through. So the changes that occur between 0 and 18 are huge. And so therefore, to think that we can simply apply children's rights in a uniform way across that age range is completely unrealistic. What we have to understand is that all children have inherent rights, even babies, but that as children grow older, then their views become more and more important. So knowing what is in their best interest won't just be determined on a kind of analysis of all the facts and circumstances. It will also have to take into consideration their opinions, although their opinions might not be the thing that wins out in a particular balancing, but would still be a very important part of that. And then when it comes to parenting, parents are supposed in Article 5 of the Convention says that parents should guide their children in the exercise of their rights. So still making the point that children's exercise of rights is the important thing, and that parents are supposed to help children navigate that. And as they grow older, obviously there is a shifting from the early stages of childhood where parents are going to make a lot of decisions for children, rightly so, that would be normal, to a situation in adolescence where they are going to start to have to consider the child's views and opinions and factor that into how to guide them in the exercise of their rights. So I think we need to do more parental education about this. And when it comes to judicial officers, it's also understanding that it isn't just a matter of one size fits all. We're talking about older children, adolescents, they have opinions, and even younger children have opinions, and we should know what they are, even if we do not necessarily say, well, of course, not every 10-year-old's views are going to be dispositive of the matter, but every 10-year-old's views are still important to know. And also remember that the opportunity to express an opinion is in itself a right. And often when we're thinking about access to justice and the experience of justice and remedy, children would feel more as though they were fairly treated, and that's how they tend to see justice, if they were given an opportunity to express a view. And if it is explained to them why they can't always get what they want, but in a responsible and respectful way that takes into consideration that they do have opinions, but that sometimes has to be balanced against other important considerations as well.
Thank you, Professor Skelton. Sorry. I see there are two questions in the chat, but Professor Jacob Joseph has raised his hand. Professor. Would you like to go ahead, Professor?
Yes, sure. Thank you. Thank you for the opportunity. My question is one of the current issues that is being encountered by the Indian legal system, particularly in the context of the Protection of Children from Sexual Offences Act, is the question of criminalizing consensual sex between teenagers aged between 16 and 18. And in 2023, we had the then Chief Justice of India urging the Parliament to reconsider the age of consent when it comes to the offences under the POCSO Act. And very recently, we have a submission being made to the Supreme Court by one of the senior advocates of the Supreme Court, Ms. Indira J. Singh, to treat this consensual sexual relationship between teenagers aged between 16 and 18 as not criminal. So how do the other jurisdictions deal with this issue? It will be very insightful to know about this. Yeah.
Professor Joseph, that's actually one of my favorite topics. I'll start with South Africa because I was involved as counsel in the Constitutional Court case that declared a law unconstitutional in South Africa because it criminalized consensual sex between adolescents. In that case, the age group concerned was 12 to 16-year-olds, and the law had been changed to it was a progressive law, but it overreached or overstepped by saying that children between 12 and 16, if they engaged in consensual sex with one another, would be both committing an offense. That clause in the Sexual Offences Act was challenged and was found by the Constitutional Court to be unconstitutional. It's a fantastic judgment. It's called Teddy Bear Clinic versus the Minister of Justice. Teddy Bear Clinic versus the Minister of Justice, and I really encourage you to read it. I think it's a world standard judgment, which I think can be very helpful. Basically, it rests on the idea that sexual expression between adolescents that is consensual in nature is part of normative development of adolescence and therefore cannot be treated as a crime. The Committee on the Rights of the Child's position on this is also nuanced and flexible. And quite often the committee does ask states to be careful not to criminalize adolescents. You will find this also in general comments of the Committee on the Rights of the Child. So the Committee on the Rights of the Child does not encourage states to go for these harsh approaches of, criminalizing all consensual sex between adolescents. The whole idea originally was to protect children from adults. But somewhere along the line, we got a little bit of confusion and I think some unintended consequences. Always tricky when one's dealing with these age limits and bright lines in law. Unfortunately, law needs certainty, and that's why we tend to go that way. But it doesn't deal with, doesn't deal very well with the nuances of these circumstances, as I'm sure this is exactly the point that you're raising. So I hope that judgment will be of use to you, as well as the fact that you may be able to find jurisprudence from the Committee on the Rights of the Child that supports you. Has
the committee on this, has the CRC come out with any general comment on this aspect?
There is general comments on the rights of children as adolescents, which you will find useful in this regard. And also in there, funnily enough, a more recent general comment number 25 on children's rights in the digital space, in other words, the digital environment, also makes the same point about sexting, not to criminalize children if they're sexting with each other. Of course, there are dangers there because that material can be used by a third party in a non-consensual way. So that is harder and more tricky. But even there, the committee has advised. And so I think, and then in concluding observations to states parties, at times, the state has also given advice relating to this. I seem to remember Singapore was a country where the committee raised this in concluding observations.
Thank you very much. Thank you.
Thank you. I see that there's another raised hand there. Honey Tuttle, please go ahead.
Hi, Good evening, ma'am. My question is, in the family code, we can see the parental alienation, which is really an evident denial of the right of the child. So it is globally important matter, I think. So what does the committee, is there any involvement in dealing with this issue, the parental alienation, which is common in all the family codes, I guess. So what is your opinion again about this?
The committee hasn't taken a position on parental alienation. And I would say that perhaps the reason for that is that there is a little bit of caution that parental alienation, even if it is real, is often also used by adults to drown out the voices of children. To say it's not the child that is saying this, it's the other parent that is, influencing the child and speaking through. Now, I know on a day-to-day basis in the courts, this is a difficult thing to deal with. I understand that. But at the same time, I think you get my point, that it's only one step away from it masking what the child's actual views are. And that's the tricky thing. So I think the committee's advice, if anything, but there isn't anything really at the moment published, but my sense is that the committee would take a cautious approach and advise a shift to a child-centered analysis rather than a parent-centered one. Probably not what you're expecting to hear, but that I think is the case.
Okay.
Thank you, Professor Skelton. I see that there's a question from the police. Would you like to go ahead, please?
Ma'am? Hello, ma'am?
Yes, please go ahead.
Hello, ma'am. My question is, you have a large experience in working as a child rights ambassador in South Africa and different arenas. What are the landmark projects or peculiarities you have seen in South African child rights system, which you want to be a part and parcel of Indian child rights system? Whether you can speak about it, ma'am?
Yes. So a number of things that I think have been interesting and useful in South Africa in the child justice system. One of those is that there are alternatives to arrest. So when children are first come into contact with the law, it's not mandatory for all children to be arrested. They can also be taken back to their parents and issued with a written notice to appear at a preliminary inquiry on another day. And at that preliminary inquiry, it is not an adversarial process, but quite an inquisitorial process with the parents, the child, the presiding officer, and they sit around and try to determine what's going on here. Is this a serious situation, or is this something relatively minor? Could the child go home immediately to the parents and stay there? So in many ways, there's a kind of stop and pause right at the beginning of the process that stops children from just being sucked into the system and determining how can we deal with this best? And then the possibility of diversion. Prosecutors have the possibility to divert children, but if they don't, the courts, again, have another chance to consider diversion, even after the prosecutor might not have decided to do so. And at any stage during the proceedings, it's possible to convert a case back to a diversion so that the child doesn't get a criminal record. So those are all positives that I see, and maybe you have some of these things already in the Indian system, where I would say the Indian system is more progressive than the South African one is your sentencing, because I think your sentencing, the length of periods of sentencing is quite short under your act. And also the fact that children are in specialized centers for children. So I think in South Africa, we have something to learn from the Indian system there as well. But this also, as we saw, comes under pressure. And when you had that famous case of the rape incident on a bus, the pressure then was to try and make it tough for all child offenders in India. and to take certain age categories out. So that's the difficult balancing thing. If you have longer sentences for some types of offences, sometimes it makes it easier to be able to treat more children as child offenders. I know this is a journey that you've walked already in India, and I think your system sort of survived, which is very good. But these are pressures that all systems do come under. So those were my takeaways.
Thank you, ma'am. Thank you.
Thank you. I have a couple of questions on the chat that ask whether you could elaborate a little bit on how the committee has reflected on the protection of children within the digital space. And if you could also maybe add your own personal reflections.
Yes. Well, you know, it is a space that is very challenging. And I think we all know that this is just going to get more and more complicated. We can see where it's going now. In fact, the committee's general comment on this is General Comment 25, and it was written 4 years ago. And already you could say it's a little out of date because it doesn't have a lot on AI, for example. And now everybody's talking about children's rights and AI, right? But what it does do is it tries to strike a balance between recognizing that there is a lot in the digital world that is very positive for children, and that they are, you know, optimally using digital technology, but also at the same time that there is a lot of risk for their exploitation. Everybody tends to think about sexual exploitation, but there are other types of risks, such as financial exploitation as well as, you know, children becoming addicted to being in the online space all the time, socialization impacts and so on. So quite a lot. So really what the general comment does is it tries to identify what states' obligations are. It does have a section on what business obligations are as well, but primarily it's the state that has to try to regulate the use in the online space. Of course, lately we've seen some of these debates about, is it a good idea to block children from all social media below a certain age? I think the committee's perspective on that, I'm certain, in fact, would be probably that's not the way to go, that there should be more regulation by the industry to protect children from harms. But actually, children also need to learn how to operate in the digital space. So cutting them off until they're 16 just delays, you know, their skills development in how to navigate and understand what's going on. And how to learn to have their own judgment about whether you can trust information that you see in the digital space. So that's the position that the committee takes. It's quite a balanced and nuanced position, I would say, but also probably very quickly will become outdated. This is something that's just going to have to keep on being updated as the technological developments keep us on our toes.
Thank you. I see another question in the chat that states that children are the most impacted and threatened by today's global environmental crisis. You've already touched upon this during your presentation, but maybe could you tell us a little bit more on how, within the framework of a national system, we can better engage children when it comes to these themes?
Yes, I mean, I think that it's really interesting that, you know, we know that there are, for example, environmental impact assessments that go on that are requirements, but up until now, very rarely did people consider children's involvement in that. But I think it's actually crucial, and maybe it's going to become more practice in the future to include in environmental impact assessments child participation in these consultations. Which I think is very useful because, you know, for example, when there are mines that damage the environment, but there's usually a plan to fix everything up afterwards and restore and so on. But who's going to be there to monitor that? You know, the middle-aged people will be too old 30 years later when the mine's supposed to have been finished. So it's really important for children and young people to be fully engaged with these endeavors and to become part of the future monitoring to see that the promises that were made were actually kept. I also think it's really important for children to have access to high quality education in this regard and curriculum. So that's another thing that's in the Convention on the Rights of the Child in Article 28, or is it 29, one of the education articles says that children should be educated in the natural environment, about the natural environment. And so there's actually an imperative under the convention for that to happen. And I think many school curricula are a little behind in keeping children's knowledge up to date. It's also important how that's imparted to them, because we know that there's a lot of climate anxiety. So lots of children are also like freaking out because they're worried that the world is going to get destroyed and they don't have a future and so on. Well, that's a bit of an exaggeration, probably. Well, some would say not. Someone would say that was a typical middle-aged woman's saying that, but children would say, yeah, that there really is a risk of this. But anyway, that mental anxiety also needs to be dealt with. So, and it can't be dealt with by saying it's not real or it's exaggerated, as I just said. It actually has to be understood and engaged with, and we need to find proper answers. And part of the answer is understanding what's really happening. So the more children really understand what is happening, the more they're able to see balance and to understand different perspectives and to see that there are still mitigations that can be done. There are still adaptations that will need to be done, but that it isn't all over. There is still hope, and that they can be part of those hopeful solutions, and their education must equip them to think out of the box and come up with the solutions that so far haven't been found.
Thank you for that. There's a rather interesting question in the chat that says, in your work with the UN Committee on the Rights of the Child, what was the most surprising lesson or experience you had in relation to how you see children perceiving justice?
Well, actually, what is interesting is that when you talk to children about justice and hear their experiences, they often say that they want people to be fair towards them. So they have this understanding about justice, which is that there's unfairness in the world and that things need to be more fair. And it's such a simple idea, actually, but I think if we really think about it, we can see that sometimes children's perception of justice systems is that it's not fair. And the more voice they are given and the more explanations they are given, taking that time to really try to listen to children and to give feedback to children and not sugarcoat it, but at the same time deliver it with the empathy that Justice Dias referred to. I think these are the key ways in which we can make justice feel like justice, make it more fair for children, even though we all know that children are not always going to be happy with the outcome of a particular court case. But half the time they don't really understand what happened, and that adds to their distress and their frustration. So really remembering that and really trying to help them understand that is, I think, the key.
Dr. Anne,
Thank you.
one question to Dr. Anne. Dr. Anne, is there any statutory framework internationally that deals with children's right in digital space? We don't have such.
Yes, so the general comment number 25 of the Committee on the Rights of the Child is it's about 10,000 word document which sets out guidelines for states parties on how to better provide for and regulate children's rights in the digital space. As I said, it's a fast moving space, but it's only about 4 years old. So it's still pretty current and still rather relevant. It is available on the Committee on the Rights of the Child website under general comments.
Yes, one more question.
Probably if you Google, you can find it too.
Okay, thank you. One more question. See, somebody was talking about this teen romance and consensual sexual intercourse, then ending up with criminal prosecution, etc. It's a serious issue we face. Number of cases are coming before the court. Even, see the most often the parents file a complaint as against the wishes of the children, and even the children are not in a position to even compromise such cases. What is the scenario internationally? Here the age is 18. If it is, even if it is below 18, the consensual sex is treated as sexual abuse or rather rape. What is the international about this law?
Yes. Well, I think, you know, what happened over the last decade or so is that there was a set of tough new laws that were passed on sexual offences, like your POCSO Act and similar acts in other countries. So South Africa has one too, Sexual Offences Act. And many countries went this hard line on sexual offences. And these laws often extended the definitions of sex, of rape, of penetration, you know, extended all the definitions all at once. And then in the process, often raised the age of sexual consent. So the age of sexual consent, I think at the world average is about 15 or 16. And the old-fashioned way that this used to be operated was that if a person was over the age of sexual consent, had sex with a person who was below the age of sexual consent, only the older person would be prosecuted. And that those laws were sort of pretty well understood. Now, what has also happened is that many countries have raised their age from 16, the age of sexual consent from 16 up to 18. And quite frankly, this is just unrealistic. It's completely in denial of reality, because most people do start their sexual debut. And in the world today, of course, unless you're living in a society that is very, very strict and has only sex within marriage, which there are some states like that. But in other states, most adolescents start their sexual debut at 16. So in South Africa, the ages was even the age group we were looking at in our court case was 12 to 16. So it was an even more sensitive issue for the public to deal with, because the public were in denial about the fact that 12 to 16-year-olds should be allowed to have sex. Well, the answer is, you know, they aren't allowed to have sex, but if they do, they should not be treated as criminals. If the state wants to involve itself with preventing early sexual debut and responding to early sexual debut, it can do so, but it shouldn't use the criminal justice system to do so. It should use preventive measures, it should use educative measures, you should use social measures if necessary, but not criminal measures, because it's not criminal activity. It's between two consenting individuals. Of course, if ever we're talking about non-consensual, truly non-consensual, then it's a different story altogether. So I would say that over the last few years, there has been a series of changes to laws in different countries that have adjusted this and started to recognize that maybe you need some flexibility in the law. So the South African law, after the court case, which I mentioned earlier, called Teddy Bear Clinic versus the Ministry of Justice. After that court case, the law was adjusted. And the current law in South Africa is that if the minimum age of sexual consent is still 16, the age of sexual consent is still 16, but if children between 12 and 16 engage in sexual intercourse with each other, that is consensual, that is not treated as a crime. The 16 and 17-year-olds also, it is not initially treated as a crime for that group either. So essentially, there's a lot of protection in the South African system, but it wasn't like this originally. This is what I'm trying to explain is, just like you, we also had a new Sexual Offences Act that kind of was oversimplistic. And we saw that many adolescents were being criminalized as a result of this, particularly boys, but not only boys in our case, because in our case, the law was also affecting girls. And so consequently, we challenged the law, and as a result of that, the law was changed. So South Africa is a very good example to look at, and I would strongly recommend that you look at it as an example. But it's not the only one, and I can say that in other African countries like Kenya, and also in Zimbabwe, also in Malawi, exactly the same issues are coming to the fore. And again, the judiciary there is also calling for the law to be reviewed in order to prevent this from happening. So your experience in India is by no means unique. And it is, there are definite moves afoot. You could also look at, I think Australia has adjusted their law again, since they also had some issues with this, so that there is more flexibility in this. And then when you are looking at this area of the law, don't forget the digital space. Sexting is another area where children are being harshly treated by the criminal justice system very often. But in fact, the behaviors are consensual. The only problem there is that they are highly dangerous because of the fact that the material might be used by a third party. So children certainly need to be well educated about the huge risks of being involved in sexting. But again, we don't make it any better by treating them as criminals.
In India, 3 high courts suggested to reduce the age from 18 to 16. And the law commissioner has even suggested that the sexual intercourse between the age group of 16 to 18, at least it leave to the discretion of the court to decide whether actually the offense is committed or not. But that has not been.
Yes, I mean, the thing is, I can see the logic of relying on discretion because consent is sometimes difficult to determine and so on. But I guess one of the problems with it is that you'll end up with a lot of very different decisions depending on the judicial officer's perception. So more certainty might be wiser. I would say it wouldn't be contrary to children's rights to reduce the age to 16. It would be in line with many other countries in the world that does have the age of 16 as the minimum age or the age of sexual consent.
Yes, Kiran, we have reached the scheduled time. 5:50 is our scheduled time. So, Professor Dr. Anne Skelton, thank you for your wonderful interaction with our participants. You have shared your experience, expertise with the participants to the each questions passed to you. So thank you on behalf of the Academy and on behalf of all who've gathered the virtual platform. I express our deepest gratitude to you for sharing your experience, expertise, insight to all of us, to the benefit of all of us. Thank you, Professor Dr. Anne Skelton, for cooperating with the Kerala Judicial Academy. Thank you once again. And Hon'ble Mr. Justice C.S. Tyers, His Lordship was present throughout the session. Thank you, Lordship, for sparing your valuable time for the benefit of the participants and also for rendering your service to the Kerala Judicial Academy. Of course, this is the 3rd episode of the Kerala Global Justice Dialogue hosted by the Kerala Judicial Academy and Nuremberg Principals Academy. So we will have another session soon. Till then, it's bye from our side. See you on with another episode. And Kiran, you are cooperating with the Academy. You are extending all your support for the success of this program. On behalf of the Academy, I also express our gratitude to you. Thank you, participants, for having turned up to that. And Dr. Justice Kauser Adapaga, His Lordship was also present virtually in this platform and asking questions. Thank you, Dr. Justice Kauser Adapaga, for participating in the program. And thank you, the participants, once again from the side of the Kerala Judicial Academy and Nuremberg Principals Academy. See you all for the next time with another episode of the program. Till then, it's bye from the side of the Academy. Thank you.
Yes, sir.